Hello, everybody. It is now according to this clock here, it says 4:35, but I want to get jumping in right away because we have a very special guest that has a time limit on his ability to speak with us, as he has another place to be. And so I want to give you a chance to hear what he has to say. And so I'm starting the meeting officially. Welcome, and then we'll just see as people come in, they can sit and hopefully catch some of the things he has to say. So David, welcome. Glad that you could be here. Where's David? I don't see him on the screen. Now I see somebody else.
I'm here.
Good. We have David Smolker, who is an attorney at law, and he has been working on two cases that are significant to Siesta Key. And we're really glad to have him because he's really good at what he does. And we're going to have a legal status update on two issues. And I don't know if you have a preference, David, as to which one you begin with.
I don't. First of all, I appreciate those kind words. I don't know how special or good I am, but I try. The two matters that I want to debrief you on are one, an appeal. An appeal that was filed by Jim Wallace challenging the denial of standing to challenge the FDOT's decision with respect to a new access point and traffic signal on Stickney Point Road, about a quarter mile from its intersection with US 41. Obviously, you folks know of the significant traffic problems that are already being experienced on Siesta Key. And interestingly enough, those same sort of traffic conditions have existed for a number of years. And barrier islands really present sort of a special issue for traffic and regulation of traffic because they have very few points of ingress and egress. So Jim was denied standing by the DOT. He appealed that ruling to the Second District Court of Appeal. We basically argued that barrier islands are different. The people that live on barrier islands have a special particularized interest in ensuring that the traffic on the roadways they depend on to get on and off the barrier islands are maintained with some reasonable degree of traffic flow. And that's what we argued to the Second District Court of Appeal. We told them that we thought these were, in the final analysis, could be life safety issues, because if you live out there, it's different than if you just work out there, and it's different than if you just go out there to go to the beach. The people that live out there have a special interest. Unfortunately, the Second District Court of Appeal denied our appeal. They did so without writing an opinion, which is unfortunate. But they do have that ability. They basically were saying that DOT's decision was the right decision, which we don't agree with, but they have ruled. We subsequently filed a motion asking the appellate court to write a written opinion, because when they issue what's called a per curiam affirmance, they just affirm the lower tribunal without writing an opinion. You're sort of very limited in your ability to go any further with appeals to say the Florida Supreme Court. In fact, you're almost precluded in the absence of a written opinion. So we asked the court for a written opinion, and they elected to deny our motion, which means that we're now looking at other options that we might have to try to address the problem that's been created out there. Can't really get into a lot of detail on them because, one, they're kind of speculative, and two, I think at this point they're closely held between attorney and client. So there's what we call the DOT appeal situation. The second matter that we're involved in is on behalf of several condominium associations as well as an individual, and we have challenged the legality of the two hotels that were approved by the county commission in November of 2021. One of them is known as Kali Miramar, and the other is known as the Old Stickney Point Hotel. And the basis for our challenge is rather interesting. The county has a policy, 2.9.1 in their comprehensive plan that prohibits increases in density and intensity of use beyond that which would have been allowed in March 13th of 1989. You probably are wondering, where does that date come in? Well, based on our research, the reason that was selected was because since 1975 and all the way up to March of 1989, the county had comprehensive plan policies that restricted density, increases in density and intensity of use. And clearly, a hotel would be an increase, 2 hotels would be increases in density and intensity of use. And the reason is really twofold. One is our research indicates that the regulations in March of 1989 treated hotels as what are called transient accommodations. And if you read the zoning ordinance that is applicable to both of these properties, it was CG, commercial general. And if you do a careful reading of the regulation, hotels were simply not permitted in a CG district. There's an alternative argument that they were permitted, but that their density would be limited. But even then, that density is limited to less than 30 units per acre. And both of these hotels are well in excess of 100 units. And so that's the argument that we're making in that case. It is similar, and it's actually identical to the argument that's being made by Lourdes Ramirez, who's also challenged the Cali Miramar Hotel on the same basic grounds. They have already filed and argued in front of the judge a motion for summary judgment in their favor, which if Judge Walker agrees, then it'll essentially knock out the Cali Miramar Hotel approval. And since we also challenged the Cali Miramar Hotel approval, it would effectively end the case, other than to do a few procedural steps in our case. Additionally, the same identical issue is present in the case of the old Stickney Point Hotel. And so if Judge Walker rules in Lourdes Ramirez's favor with regard to that legal issue, it would apply equally well to the old Stickney Point Hotel. So in that case, since the issues are essentially identical in part for all of the hotels in both of the cases, the judge is in all probability going to consolidate the cases for trial purposes, assuming that a trial is necessary. And we are now in the process of trying to reach an agreement with all parties, including the interveners in the county, developer interveners, to reach an agreement with respect to a new trial date where both cases, the 2 cases, would be tried together because they involve basically the same legal issues and many of the same factual issues. So that's where we are as far as those 2 matters go. And I do have some familiarity with Sarasota, having gone to New College and graduated from there. And barrier islands are different. And I think that the court system, I'm hoping, will at some point along the way realize this and recognize that people that live on barrier islands do have to have maybe a little special treatment when it comes to traffic related issues, because they've got more at stake ultimately if there's bad decisions made on the mainland or near the mainland that affect the only ingress and egress that they have, especially as it relates to hurricane evacuation and emergency medical services and emergency fire services. So
David, could you check your volume and see if you can push it up a little higher?
oh, certainly. I'm sorry.
Right, make it higher.
Yes, let me try that. Well, according to my speakers, I'm as high as I can go. So I had pretty much finished. I don't know whether folks couldn't.
I have it on the recording, so it's good. It's good.
Okay, good. So any event, I appreciate the opportunity to speak before you and let you know that that Jim Wallace and several other folks are trying to fight the battle to try to be able to figure out a way to kind of lessen the risk for people that live on Siesta Key when it comes to getting on and off the island. I am aware that there is a move afoot to incorporate, and I think that in the final analysis, that may be the best way for the residents of Siesta Key to go, because you will then have control over the land use decision making that occurs on the key. So any event, thank you very much. I've got a few minutes. I would be happy to answer questions that I can.
Do we have any questions?
Oh, you guys are an easy audience. Ooh, thank you.
Well, I
Okay,
think you did a great job.
John,
Okay, we have one person over here, John Morton.
Attorney Smolker, John Morton with Siesta Sand and Paper. You see benefits in the consolidation of the potential consolidation of the two cases.
Yes, I do. And there will be economies of scale involved because the issues are the same. In many instances, the expert witnesses are the same. In many instances, the expert witnesses will be saying the same thing about the hotels. And under the rules of civil procedure, there is a rule that specifically governs consolidation under circumstances like this. And so I was expecting the judge would consolidate it of his own motion, but the interveners filed the motion for intervention, and I think all the lawyers agreed that it was appropriate under the circumstances. And frankly, one of the advantages is going to be that if we get if the judge rules in Lourdes Ramirez's favor on the pending summary judgment motion, it could effectively end the case, our cases as well. We would still have to go through procedural steps, but once he rules, that's going to really be dispositive of the issues in our case. And so it may be because it is going to be consolidated, that we will get the benefit of their ruling in the Lourdes Ramirez case, as well as having the ability to make the case from a trial standpoint quicker, easier, and more efficient.
John,
So my apologies, I'm a little bit confused. If Walker rules on Lordy's case first, doesn't that wipe out consolidation?
Yeah, it could. It would wipe out consolidation, and it would probably eliminate the need for a trial at all in either case.
So, okay, wasn't Lordy's case supposed to go to trial March 27th?
Yes, and they had a pretrial last week, I believe it was, and Judge Walker basically said you're not going to be able to go to trial on this schedule because there's a number of other cases ahead of you that have priority, in the 3-week docket. So, right now they don't have a new trial date, and the judge has instructed us to get together with all parties and try to work out a new consolidated trial date, which at this point will probably be sometime in the fall.
Okay, so the idea of the Colleen Miramar / Old Stickney Point trial being in June, regardless of Lordy's case, is no longer even in play. It's going to be delayed regardless, do you think?
Yes, I think that's accurate. One and primary reason is that if you're going to consolidate the trial, now you've got to have a date that works for everybody. And our trial date doesn't work for us. We represent 88 people in a major case involving 540 beachfront property owners in the Panhandle, where we're defending against the Walton County claiming public customary use of privately owned dry sandy beach. And so we have a 8-week trial that's scheduled to start in May. So we would have to continue our trial on any of that. So the consolidation is wise. It really becomes a question of when we're going to be able to get a date that works for everybody.
So again, to just hear you right, that even if there's no consolidation, June for the trial that does not involve Lordy's is not going to shake down in June, period.
Well, ultimately, the court has to grant the motion for continuance, but I think he will under the circumstances.
Thank you.
Got a question.
Yes.
That's it, David. Thank you so much.
Okay, well, thank you for having me.
We
I
have
appreciate
one,
it.
we have one more question if you have a moment,
Sure.
from one of our members, Bill Boris.
Bill, can you come forward?
Yes,
Just speak loud.
I got a question. Does this Judge Walker have a history of any judgments or opinions on anything to do with the hotels or anything similar?
You know, I don't know. I can tell you that I think he's a very good judge and he tries to get it right and he's fair. And that's all you can really ask if you're a lawyer.
Okay.
Thank you, Bill.
I jump in?
So are we timely then for you?
Is that good, David? I think we're out of questions.
Okay.
Okay, very
Great.
good. Well, thank you very much.
And
Thank
thank you
you.
for being on with us today. Thank you very much.
You're welcome. You all
Bye
take care.
now.
Bye now.